Conducting test recording. Testing judge's mic. Testing responding mic. Testing applicant mic. Testing witness mic.
Testing responding mic. Testing applicant mic. Testing witness mic.
Test recording completed successfully. Okay, so for your information, the microphones in this room have now been activated, and all conversation in this room is now being recorded. Before I start, I just wanted to ask if there's any confidential representations today. No? Okay. And the other thing, I just want to do a brief roll call. I've got Mr. Nuttall, Ms. Gorofsky, and Mr. Bagley. Okay. And Mr. Tosto?
I will not be making submissions.
You're not, okay. So everyone in the back, you won't be named then?
You should be on the record. Ms. Popple should be on the record.
Ms. Popple?
And you're with which party?
This side.
With the Finkel, okay. Okay, and Mr. Natras, is that you? No? Okay. Okay, good to go.
Order report?
The special sitting of the federal court in Calgary is now open. The Honorable Justice Russell is presiding. The court calls file T-1964-17 between Wael Maged Bagley and 103-8482 Alberta Limited, also known as IntelliDo Technologies Incorporated, and Fidelter Incorporated, and Bill Hughes, and Missing Link Business Operations Advisors Limited, and Gordon Edwards, and Christopher Beadle, and Shane Rogers, and FLIR Systems Incorporated, and FLIR Systems Limited, and Spartan Controls Limited, and Canada 150 in 150, and Schneider Electric SE, and Schneider Electric Canada Incorporated, and West at Pelco by Schneider Electric and Enbridge Pipeline Incorporated. Appearing on behalf of the IntelliView defendants, Mr. Evan Nuttall, Ms. Robin Gorofsky, and Ms. Laura Popel, and appearing on his own behalf, Mr. Wayo Maged Badley.
Good morning, nice to see everyone. Please take a seat. We have a few preliminaries to go through before we get underway, so you might as well be sitting comfortably. I would normally spend some time in this type of hearing ensuring that a self-represented litigant is comfortable with the process and knows what lies ahead. But I see from the record, Mr. Badawi, that you're quite an experienced litigant. And I think in your case, I probably don't need to explain what this hearing is about and how it's going to proceed. Is that correct?
I'm not an experienced litigant, my lord. However, I have very well knowledge of the procedures, and
Okay.
I practice laws in different countries, so I'm very aware of
All right, okay.
the process. So thank you very much, my lord.
Okay. So let me just, rather than go through those basics, let me just remind you of, as a self-represented litigant, of a few important issues to keep in mind. And these are, from my own experience, mistakes that self-reps often make. Bear in mind, of course, that as a self-represented litigant, you're still bound by the same rules of procedure, the same rules of evidence, and the substantive law applicable to the issues before us, as any other litigant would be. You also bear in mind you're not here today to give evidence. All evidence relied upon must be in the affidavits filed or apparent on the face of the record. Self-represented litigants often feel it's, they find it's hard to distinguish, but just try and keep that in mind. So you're here today to pursue and present legal argument based upon that record, not to supplement it with further oral evidence. Now, however you present your case, of course, is up to you, but bear in mind that there is a limited amount of time that's been set aside for it, so be careful to keep to what's relevant to the motions. And we'll talk about time a little later, because depending upon what we're hearing today, we need to talk about time and how we're going to do it. You know, of course, that you must tell the truth at all times and not seek to mislead the court. And finally, if you have any doubts about how with the procedure, just raise them. Don't hesitate if you're in any kind of doubt, and I'll assist in any way I can. I have to remain an impartial judge, but I can direct you. Okay, that's probably all I think I need to say to you on that. So let's decide, first of all, what we're doing today. Mr. Badawi, the reason I'm asking this is that in your motion dealing with the appeal from the prothonotary, on the face of the materials you refer to 3 rules. One of them, let me have it. One, of course, is the normal prothonotary appeal rule, but you also refer to Rule 343, which is a rule dealing with appeals to the Court of Appeals, so I don't think you need to bother with that. But you also say you're relying upon Rule 369, which, of course, is the rule that deals with written motions. And normally, the reason I'm asking you this is because normally speaking, this kind of simple appeal from a prothonotary would be dealt with in writing pursuant to Rule 369. So I'm asking you, was that your intent?
So to be very focused and very direct, my intent with this motion record is 2 things. Number 1 is the schedule of the prothonotary allows me to put in a supplement material on the same deadline for this hearing. So when she scheduled when we will question and have the whole schedule in her order, she allows me to do this. So the original application was actually in writing, and I put supplement information. However, there is a motion on challenging the decision not to answer questions and not to produce an undertaking,
Right.
which is, in my opinion and my understanding of the common law, it must have a preceding hearing before, because this is an evidence which will be before the court. So if I miss one of the...
No, I'm just...
yeah, so this is basically my intention.
I realize that why you want to have that motion decided, but before me today is this appeal motion from the Bratharntrie's decision.
Yes, ma'am.
She basically says no to that particular issue. Did you want me to decide that motion in writing, or...
No, I would rather having this in oral hearing, because I would rather making an oral submission as
I
well.
understand that, but as I say, it's a simple motion. I mean, all I have to decide is whether she made the right decision or not.
Yes.
And normally that would be dealt with in writing, because of course we don't want to take up expensive court time. So is there any particular reason why you need to argue that rather than me dealing with it in writing?
Because, my lord, in my submission to the court, the premises and the grounds of the motion of defending the motion under subsection 4E and my motion they are the same facts, they are the same grounds. There is no much difference.
Mm-hmm.
And I don't want to get into the merit of the motion before your lordship allows me to do that. So I'm trying to explain it from the outshell without getting into the guts of it, because this, I believe, what's required. So in my submission here, my submission is 5 pages, and all of my submission for both motion, why the court shall not grant the motion of BLG, and why I should get this information from the questioning party after paying. My submission that the grounds are the same. So if I say this submission, the court shall decide both together. I'm not sure if this is legitimate in the legal proceedings. However, I don't want to abuse the court time. I don't want to waste everybody's time. I just want to be very specific.
Okay, so your intention was then that we would hear that motion orally,
Yes,
the
ma'am.
motion orally. Okay, then please sit down and we can proceed further. That being the case, Rule 3 of the rules, of course, compels me to interpret and apply our rules of procedure so as to ensure the just, most expeditious and least expensive determination of every proceeding on its merits. So I think what we need to do then is to decide how we're going to deal with these 2 motions here today. You've confirmed my own thoughts on this, Mr. Badawi, that when I read the materials, it seems to me there is a considerable amount of overlap between these 2 motions, and you know and what you raise and what you wish to argue. And that being the case, I think in accordance with Rule 3, and subject, of course, to anything either side might like to say to me on this, my instinct today, and so that as he's pointed out, so that Mr. Badawi does not have to repeat himself because of the overlap, I think I should hear these motions conjunctively, and that will mean that because I want to hear the big bulky one first to get it out of the way, the defendant's submissions on the vexation motion will go first, and then secondly, Mr. Badawi will then respond to the vexation motion, but also immediately after his response to the vexation motion, he will make his own appeal motion, because we want to, where the overlap occurs, we don't want you to have to repeat anything of what you say. So you will make your appeal motion at that time together with your response to the vexation motion. And then the third step will be the defendants will then reply to Mr. Badawi's response to the vexation motion and respond to his appeal motion. And then finally, you get the last word, Mr. Badawi, you will reply to your own appeal motion. Okay, everyone understands that? Okay. So let's talk then about the timing, and we have to work within the parameters. We usually take an hour for lunch, and we usually break about 12:30. That can be adjusted, of course, to fit your presentations and the needs of the hearing as we go along, but that's what we aim for. And subject to any rulings I might make along the way, I've said your presentations are up to you. However, there are time limits, and both sides have to be cognizant of the need to divide the time fairly. And I would suggest that you keep in mind the following. From reading the materials, outside time limits I'm talking about here, you don't have to use all of this time, but as outside time limits, I would think that the defendant's vexation motion, your first, when we first get going, should take you no more than about 1.5 hours. Mr. Badway's response to the vexation motion and the presentation of his own appeal motion, I think, 1.5 plus 0.5, which I think will give you 2 hours. And then the defendant's reply on the vexation motion and the response to the appeal motion, about an hour, I would think. And then finally, Mr. Badway's reply to the appeal motion, about 0.5. That works out about 2.5 hours each, I guess. That's the way we've divided up the time. As I say, we don't have to use that time. We don't need it. But I will be watching those times because we only have today. And I'll remind you if I need to do that. Okay, now that's all I want to say. Any questions, or can we just begin? Okay, let's go. Let's start.
Thank you, sir. And for the record, it's Robin Gorofsky from Borden Ladner Gervais. I'm appearing today on behalf of the IntelliView defendants. What I would propose to do, sir, Mr. Justice Russell, is deal first with service, the materials that should be before the court, and then I'll get into the substance of the motion. I want to address service, sir, because there have been repeated concerns raised by Mr. Badawi with respect to service, or in his view, lack thereof. So I'd like to walk the court through the various affidavits of service that have been filed. First, with respect to the original IntelliView motion record filed on October 16th, 2018, this is the motion record comprising 5 volumes in support of the Section 40 motion. I should point out first, sir, that a notice of consent to electronic service was granted in these proceedings. Mr. Badawi signed off and consented to service electronically at his email address of badawi@badawi.ca. So the motion record was served in accordance with the consent to electronic service on October 12th, 2018, and an affidavit of service was filed to that effect. It was an affidavit of Elizabeth Walker, sworn on October 12th. Mr. Badawi subsequently complained of not having received the documents, and so the motion record was subsequently couriered to Mr. Badawi's home address. This is the home address for service in the Alberta Court of Queen's Bench action. It's also the address noted by Mr. Badawi on the consent to electronic service filed in this action. An affidavit of service of Elizabeth Walker was sworn on January 2nd, evidencing service via courier of the motion record on December 18th, 2018. And in that affidavit of service, Ms. Walker swears that she received a phone call from the Office Services Department indicating that the individual at the address for service refused to sign for the courier package and informed the courier to leave the package in the mailbox. And so that's what was done there. Mr. Badawi continued to allege that he did not receive the materials and that the motion could not proceed. So in order to avoid any delays of this hearing, we did something a little bit out of the ordinary. We contacted the registry and asked if we could deliver hard copies not only of the October 16th motion record, the 5 volumes, but also the reply written representations filed on behalf of the IntelliView defendants on November 21st. We delivered hard copy of those to the registry so that the registry could arrange for Mr. Badawi to pick them up. A letter enclosing the court-filed materials was sent on January 25th, 2019, and it was actually recorded by the registry on the court file. So by providing hard copies to the registry, which is not something I would imagine the registry wants to deal with regularly or at all, we believed this would obviate the need for any further adjournments with respect to service. And on that basis, it is our position that service is in order and the vexatious motion should proceed today on the basis of service alone. I indicated that the November 21st reply written representations were sent to the registry for Mr. Badawi's pickup. They were also served on Mr. Badawi via email on November 21st, and an affidavit of service of Elizabeth Walker was filed on November 21st reflecting that service. Finally, as we are dealing with Mr. Badawi's appeal motion today, I'll also point out that while I'm dealing with service, that the March 25th responding motion record of IntelliView responding to Mr. Badawi's appeal motion was served on Mr. Badawi as well as the service list on March 25th at the email address provided in accordance with the consent to electronic service, and an affidavit of Elizabeth Walker was sworn and filed on March 25th, 2019, reflecting this service. Exhibit A is the email reflecting that went out to the service list, and Exhibit B to that affidavit is confirmation of delivery of the email. Now, sir, I have copies of these affidavits, should you wish to see them, although I understand they are on the court file.
Okay, if I have any problem finding them later, I'll let you know. But
Thank you.
Just hang on for the time being.
This is an application by the IntelliView defendants pursuant to Section 40 of the Federal Courts Act to declare Mr. Badawi vexatious litigant motion. We filed our written representations and submissions on this, which are found in Volume 5 of the motion record.
Yes, I should have let both of you know. I have read your written submissions, both sides.
Thank you. I would ask the court to focus its attention to one single question that I would say is really the only really relevant question the court must consider in the context of this application, and that is whether the court record demonstrates a pattern of conduct that permits the court to reasonably predict future abuses. So there may be other allegations raised which we'll deal with in the subsequent motion. This is noise in the background, and the real question is what the court record demonstrates. Before I address the specific indicia of a vexatious litigant and summarize Mr. Badawi's conduct, which IntelliView submits is indicative of a vexatious litigant, I think it's important to emphasize what this and other courts have already said about Mr. Badawi's conduct. As the Federal Court of Appeal has stated in Olamide, these findings can be given much weight, and in fact, the court need not look beyond statements and findings previously made by the courts to grant the Section 40 motion, notwithstanding that there's ample evidence in addition to support the motion. I'm going to take you through some of these orders and reasons now, sir, and they are reasons in addition to those we've already referenced in our written materials. I'll first take you to Exhibit UU of the Mogert affidavit. This is at Volume 4 of the motion record on page 722.
All right, let me find my way through this.
Volume 4, Exhibit UU.
I'm with you.
Thank you. These are reasons for the decision of Justice Peter Martin of the Alberta Court of Appeal denying Mr. Badawi an extension of 1 day to file his factum, resulting in the appeal being struck out. At paragraph 10 of those reasons, which are on page 2 or 724, Justice Martin noted that a failure to file resulting in only a short delay will often be forgiven and the appeal restored if, on review, the appeal is found to have merit. In my respectful opinion, this appeal has none. I'll direct you, sir, to Volume 2 of the motion record and Exhibit P to Mr. Hughes' affidavit. P as in Peter. And again, this is Volume 2, page 186 of the motion record. And at Exhibit P is the decision of Justice McVeigh in this action dated July 7th, 2018, resulting from a hearing before her on March 8th, 2018.
Okay.
At paragraphs 12 and 13 of that decision, beginning on page 6,
I'm there.
Justice McVeigh notes, certain paragraphs of the statement of claim filed by Mr. Badawi were devoid of material facts. At paragraph 13, she states, below is an example of a vexatious paragraph likewise devoid of material facts linked to a cause of action. The paragraph reference was this: Bill Hughes is married to an Italian descent wife and he has a summer home in Italy and he is very involved in the Calgary Italian community. He has special social relationships with Frank Tosto and Laura Puppel, two lawyers from the Italian community of Calgary. Justice McVeigh notes, in addition to the above paragraphs, the rest of the content is bald allegations, speculation, and argument. At best, there are stated conclusions of wrongdoing against which a statement of defense could not be drafted in response. The defendants do not, as the plaintiff argued, have to go to their own websites to figure out what they infringed. The pleadings have to stand on their own. The statement of claim before Justice McVeigh was struck as a vexatious proceeding. At paragraph 21 of her reasons, Justice McVeigh indicates that Mr. Badawi's memorandum of fact and law, while it has argument, it is argument that does not address the substantive issues before the court. The plaintiff's only written argument regarding the actual motion to strike is at paragraph 20, where he says, the motion to strike is an abuse of process and the time of the court. Justice McVeigh notes that Mr. Badawi's earlier memorandum is also devoid of legal argument related to the substantive issues and instead focuses on perceived irregularities and other relief sought. Similar to the situation we're in today, sir. She says at paragraphs 27 to 30, the entire amended statement of claim is vexatious and an abuse of the court processes as evidenced by this hearing, where the plaintiff brought several confusing and baseless motions. First, the plaintiff has provided no account of any specific conduct taken by the defendants or their employees that could be considered a foundation for the bald allegations in the amended statement of claim. As there is no evidentiary foundation for the amended statement of claim, it is an abuse of process and can be struck. Second, the evidence before the court is that the plaintiff is known to commence a never-ending stream of motions and letters for direction, or as occurred in this case, letters giving the court directions. These never-ending matters are also an abuse of process. Sir, this tendency to focus on perceived irregularities instead of the substance of the issues is in IntelliView's respectful submission, standard operational procedure for Mr. Badawi, and is similar to the allegations he has raised today, which do not focus on the vexatious litigant motion, but the bald allegation that BLG is abusing the court's process. Finally, at paragraph 39 of the decision, Justice McVeigh ordered lump sum costs, referring to the costs to the defendant related to Mr. Badawi's ceaseless litigation.
Okay.
I'll move on to Exhibit X of the same volume, sir. It's Mr. Hughes' affidavit.
I see it. Justice Gleason, yes?
That's right. This is an order of Justice Gleason in a different federal court action, docket T12 at 89-14. You may recall, sir, this is an action commenced by Mr. Badawi against Valdemar Igris.
Yes.
He is one of the defendants in the action who was counsel to Mr. Badawi's ex-wife in the divorce proceedings in Queens Bench. This is an action in which Mr. Badawi filed trademark applications in the name of Igris Family Law on April 22nd, 2014, after learning that Mr. Igris had started a new law firm under the name Igris Family Law at a case management meeting in February of that year. Mr. Badawi then registered corporation federally Igris Family Law Ltd. and in Alberta IFL Igris Family Law Ltd. He then sued Mr. Igris and his professional corporation for, among other things, trademark infringement. So this order from Justice Gleason arises out of a motion by Mr. Badawi which sought to set aside a decision of Prithonotary Lafreniere. And in that decision, Prithonotary Lafreniere denied Mr. Badawi's motion to set aside all of the Prithonotari's prior decisions. Justice Gleason dismissed Mr. Badawi's motion, and on pages 6 and 7, Justice Gleason addressed Mr. Badawi's allegation of a reasonable apprehension of bias in respect of Prithonotary Lafreniere's handling of various motions in the matter. Justice Gleason says at paragraph 7,
Paragraph 7.
On page 7,
Okay,
beginning on the
I don't have
second
any
line.
numbers in my version here.
Pardon me, page 7.
Page 7.
Yes, page 7, second line from the top.
I see. Yeah.
Yes.
Okay.
Justice Gleason says these assertions are entirely spurious and indeed ought never to have been made. The Prithonotari's order allowing for the filing of the defendant's statement of defense and counterclaim was necessary as the plaintiff was evading service. He goes on to say at the end, the plaintiff's allegations of bias are entirely baseless. He dismissed the motion and ordered costs.
It is a she, but it's
She,
okay.
pardon me. My
I know,
apologies.
I know what you mean. Okay.
At Exhibit AA to the Hughes affidavit in the same volume is a decision of Justice Manson in the Igris action. And at paragraphs 44 and 45, which are found on page 19 or page 303 of the motion record, Justice Manson notes that Mr. Badawi's evidence contained bald statements that lacked any semblance of valid or credible evidence. Turning one tab over to Exhibit BB of the Hughes affidavit, we see an order and reasons of Prithonotary Lafreniere in the Igris action
He's now a judge, and that's how.
of the then Prithonotary Lafreniere.
Oh, it says case management judge. Oh,
He was
is it-
case
is it-
management judge, and I understand Prithonotary at the time.
All right, okay.
As we've heard before, Prithonotary Lafreniere was one of Mr. Badawi's targets at the court. Others included Justices Hall and Campbell of the Court of Queen's Bench, who are also accused of bias or a reasonable apprehension of bias. The decision of the then Prithonotary Lafreniere addressed in part Mr. Badawi's leave application to bring a motion to recuse the Prithonotary for reasonable apprehension of bias, development of bias, and alleged corruption. At paragraph 1 of the order, which is on page 2, under the heading Introduction, Prithonotary Lafreniere says the present motion for recusal is but a small chapter in a long and contentious proceeding. He says that the procedural history of the underlying action is somewhat difficult to summarize given the volume of letters and documents submitted by the plaintiff, many of which are quite lengthy, argumentative, and repetitive. At paragraph 15 of the order notes that there's similar relief being sought in different motions. And at paragraph 16, Prithonotary Lafreniere says, "It goes without saying that repeated requests for the same relief from the court, including requests to set aside previous orders and directions which have already been denied up to the highest level in Canada, constitutes an abuse of the court's process." And at paragraph 27, he says, "Rather than focusing on the proceeding, the plaintiff has chosen instead to go to war with the court. The defendants have been put to additional expense to respond to what is clearly a frivolous, vexatious, and abusive motion." We then, sir, have Justice Campbell's reasons in the Court of Queen's Bench action. Now, these reasons were provided to the court on December 4th, 2018. Have you seen a copy of those?
Yes, and I've read it.
Okay. I have extra copies here, should anyone wish to see. A few points to note from Justice Campbell's reasons. She states at paragraph 31 on page 9, "As a first preliminary point, I conclude that Mr. Badawi is not credible." At paragraph 32, she says, "I come to this conclusion because Mr. Badawi is simply untruthful in his representations to the court. He makes demonstrably false claims. I conclude he believes doing so is to his advantage." She finds in her reasons the following vexatious conduct. I'm not going to go into detail, sir. I will summarize it. She finds the existence of collateral attacks and attempts to relitigate issues previously litigated. That's at paragraphs 126 to 128 of her reasons. She finds that Mr. Badawi engaged in escalating litigation. That's at paragraphs 129 to 133 of her reasons. She finds that Mr. Badawi engaged in persistent and unsuccessful appeals. That's at paragraphs 137 to 138. She found that he made unsubstantiated allegations of wrongdoing, impropriety, corruption, and bias. And she details this at paragraphs 139 to 142 of her reasons. She finds that Mr. Badawi has failed to comply with court orders. She discusses this at paragraphs 146 to 147 of her reasons. And she found that Mr. Badawi has litigated with bad intent. She says at paragraphs 149 to 150, citing Starr and Holden from the Supreme Court, "The well-established principle in law that a person can be presumed to have intended the natural consequences of their acts may permit an observer to say with confidence that bad litigation can only be explained by the abusive litigant conducting his or her actions for an illegitimate, improper purpose. Mr. Badawi's litigation," she says, "without question reaches that threshold." At paragraph 151 of her reasons, Justice Campbell says, I can only conclude that Mr. Badawi is a vexatious litigant. There is no other possible explanation for him without any legitimate purpose, applying for and obtaining trademarks, copyright, and corporate registrations related to his former wife's counsel, and then attempting to enforce those spurious registrations in the federal court. Mr. Badawi's litigation tactic was more than an unfair imposition on opposing parties. Mr. Badawi is a litigant who uses legal processes with the intention to harass, harm, and intimidate. On his own, the single conclusion warrants Mr. Badawi being subject to court access restrictions. Mr. Badawi's established pattern of meritless and persistent filings and communications with the court warrants strict and comprehensive court access restrictions beyond a simple leave application requirement. The order granted by Justice Campbell was also delivered to the court in the package on December 14th, so I expect you've seen that, sir.
Yes.
Mr. Badawi sought permission to file leave to appeal the application, appealing Justice Campbell's decision. The Court of Appeal granted permission to have the leave application heard. Now, Mr. Badawi states in his materials that the appeal is outstanding. This is not the case. The leave to appeal application was heard and denied pursuant to an order of Justice Valdez of the Alberta Court of Appeal. Those reasons, dated February 19th, 2019, are found at tab J of the IntelliView defendant's March 25th responding motion. So much has been said by the courts. I've only summarized some of the commentary. Additional commentary is found in our written representations. And it details Mr. Badawi's vexatious conduct to date in this court and other courts. And according to the Federal Court of Appeal in Olamide, this alone provides the court with sufficient evidence of a necessity for court access restrictions. Now, Mr. Badawi suggests that the Section 40 motion is moot because his claim was struck. Now, Mr. Badawi has appealed the decision to strike the claim, so these proceedings aren't necessarily over, and it's not moot. But even if it were, the Federal Court of Appeal has determined that even where an underlying proceeding has been discontinued, a Section 40 motion brought in that proceeding was not discontinued because the Section 40 motion doesn't necessarily relate to the issues in the underlying claim. It's a separate issue. And the court held that notwithstanding the discontinuance of the action, the Section 40 motion survived and could be determined as a standalone issue.
Which case was that? I've forgotten.
That's in the Olamide case, sir. And I do have, it's not in the one that we cited in our materials. It's a different decision of Justice Stratus, and I can hand a copy of that decision to the parties.
Thank you.
And that's discussed in detail, sort of the reasoning of why the Section 40 motion is discussed between paragraphs 31 to 36 of that case, where after the Section 40 motion was brought, the plaintiff discontinued the action. And the conclusion of the court that the Section 40 motion stood on its own is made at paragraph 36 of that case. The IntelliView defendants have provided additional evidence, ample evidence, in the Hughes affidavit and the Mogart affidavit of Mr. Badawi's vexatious conduct, and evidence is summarized neatly according to the specific indicia in the written representations beginning on page 745 of the motion record.
Right.
I will briefly summarize those for the record, sir. The federal court has outlined a number of indicia, one of them being propensity to relitigate issues. Mr. Badawi continues to put matters before the court that have previously been determined. The unsubstantiated allegations about BLG's alleged solicitor-client relationship is one such example, and I'll respond to that in the context of the appeal motion. Another example is this action, which dealt with many of the same issues raised in the QB action, as that term is defined in the Hughes affidavit. Another example is when the IGRIS action was summarily dismissed, Mr. Badawi filed the second IGRIS action, substantially duplicating the claims and allegations made in the first IGRIS action. This is detailed at length in the Hughes affidavit. The Hughes affidavit highlights additional examples of the same relief sought by Mr. Badawi on numerous occasions. A second indicia includes the initiation of frivolous actions and motions. I've already noted decisions of the court and others commenting on the frivolous nature of certain of Mr. Badawi's claims and motions. Another example is found in this action, after Justice McVeigh reserved her decision following a hearing. Despite there being no decision, Mr. Badawi filed a notice of appeal seeking to vacate orders that had never been made. Counsel had to spend time responding to explain that no decision had been rendered that warranted an appeal, and the court had to spend time considering the matter. Sir, the frivolous and vexatious nature of the IGRIS action and the second IGRIS action, based on the same allegations, need not be belabored. I will point out that in the second IGRIS action, Mr. Badawi named the Alberta Law Society and the Alberta Law Insurance Association, or ALIA, as defendants. The prothonotary noted that by no stretch of the legal imagination can the plaintiff's claims against the Law Society and ALIA that they failed to protect the public, deceived the public, and promoted malpractice can be found to reasonably relate to the defendant's counterclaims. And the claim against those parties was struck.
That was prothonotary Lafreniere, I would take
That's
it.
right.
Right, okay.
Another indicia includes unsubstantiated allegations of impropriety against opposing counsel and the court. I've noted already the allegations of bias and alleged corruption against the prothonotary in this court. Mr. Badawi repeatedly alleges counsel is abusive, departs from the truth, perverts the course of justice, among other things. And this is detailed in the written materials. In this action, Mr. Badawi appears to allege a conspiracy between counsel based on common Italian heritage, and I've mentioned the allegations against the judges and prothonotary. Each and every allegation is unfounded. Another indicia is a failure to abide by rules and orders of the court. The Hughes affidavit notes all costs awards ordered by the court are unpaid, and this evidence was accepted by Justice Campbell in her reasons. Mr. Badawi also files motions which consistently seek to circumvent the appropriate court process. For example, he has a tendency to file applications to vacate or set aside prior court orders without following the appropriate process or timeline. As noted in the Hughes affidavit, Mr. Badawi also consistently refuses to accept the order of Master Prowse, upheld by a decision of Justice Hughes, summarily dismissing the claim he filed in the Court of Queen's Bench action against BLG, insisting that Justice McCarthy subsequently reinstated the claim when he did no such thing. Justice Hughes, among others, has advised Mr. Badawi that this did not occur, but he consistently ignores this advice and references this in his materials, as he's done so in these materials. It was also found that Mr. Badawi has used this action as an attempt to frustrate the Queen's Bench action with similar issues. Shortly after filing the statement of claim commencing this federal court action, Mr. Badawi applied in the Court of Queen's Bench action for a stay and an order rescinding all orders obtained in the Court of Queen's Bench action. That motion was denied. The list goes on, sir, but all of this is to say that every time Mr. Badawi files these motions, fails to abide by court orders and directions, litigants have to incur significant amount of time and expense responding, often to personal attacks that are completely unfounded. And the court has to hear the matter, using up significant resources that could otherwise be dedicated to real issues properly before the court. In summary, this is exactly the type of case in which a vexatious litigant order is warranted. Each and every indicia summarized in the federal court is present, and additional indicia noted by the courts in other jurisdictions are also present. As per Section 40 of the Act, Mr. Badawi persistently institutes vexatious proceedings. The escalating nature of the behavior provides sufficient evidence to allow the court to predict future abuses. And if the court is contemplating an order, the scope of the order should contemplate the following. First is that Mr. Badawi's conduct has shown that anyone can be the target of his litigation. He targets indiscriminately and spuriously. Parties like Enbridge, the Attorney General of Canada, Aaliyah, lawyers acting opposite to him have all been the subject of Mr. Badawi's attacks. Judges who find against him are accused of corruption and bias. And while these attacks are ultimately always unsuccessful, these parties have to incur significant costs to respond. The court should intervene in these circumstances to protect the public from this conduct and to protect the limited resources available to litigants at the court.
Have you provided me with a draft order that you want me to consider?
There is a draft order set out in the motion record, sir. We also have copies of a second order that we've added a paragraph to mirror Justice Campbell's order, and that is an order. The paragraph added requires Mr. Badawi not only to seek permission to bring a motion, but requires him to be represented by a member of the Law Society in good standing in Alberta or in whatever jurisdiction he's applying.
Have you given Mr. Badawi a copy of that draft order? I think he should see it.
So this is effectively the same order that was attached to the memorandum record. I believe it was at tab 2 of the motion record. I'm just looking for the paragraph. It's paragraph 3.
This is the one you've changed.
Is the one we've changed, and I'll hand that up to the
All
clerk.
right.
It's the addition of paragraph 3, sir.
Thank you.
Sir, the fact that Mr. Badawi's conduct has been entertained at this court, the Federal Court of Appeal, and other courts, we also submit that the scope of the order should be broad and is appropriate in the circumstances. The order's not punitive in nature. It doesn't prevent him from bringing motions or proceedings at the courts. It only restricts his ability to bring motions that are proper. The court has the statutory authority to grant such an order, and it has the inherent jurisdiction to control its proceedings and mitigate and minimize future abuses. And for those reasons, sir,
Well, the federal court has no inherent jurisdiction. It has to be a question of statute, so you're going to have to give me...
well,
I know
Section
that-
40
I know that Justice Campbell called upon her own
no,
inherent
that's right.
But the federal court's a little different.
Well, the Federal Court of Appeal noted in the Coote decision, and I'll hand that up.
Thank you.
Thank you.
At paragraph 8 of the decision. Now, this is in the context of the court's ability to stay motions pursuant to Section 50 of the Act. But the court says, this court's plenary jurisdiction is indistinguishable from the inherent power of provincial superior courts to manage and regulate their own proceedings.
Okay, yes, I understand that.
Yes. So that's where I say there is some inherent jurisdiction to control the court's process.
Right.
And the court may do this through the statutory authority provided to it pursuant to Section 40 to grant a vexatious litigant motion.
Right. Okay, I understand now.
Subject to any questions, sir, those are my submissions on the vexatious litigant motion.
No, I have no questions. Thank you for your
Thank you.
help. Mr. Badawi, it's over to you. You're going to respond first of all, I think, and then you're going to give us your own appeal motion.
First of all, my lord, I deny all allegation from BLG, and before I proceed, I would like to ask a very legitimate question.
You would like to ask what, sorry?
A very legitimate question.
Of
That's
who?
the question.
Of who?
What is the intent of this vexatious litigation? Currently, I have no actions live in the federal court. All my 2 appeals, which is scheduled to be heard on the next sitting in May, and all material have been fulfilled and done, and the office in Toronto or in Ottawa is actually putting them on the schedule of the sitting in May.
Right.
So the court has to realize that the intention of bringing a motion in, which is what they want to take it against me, is also held against the moving party, if this is actually a moving party and this party is not BLG itself. So I want to start with, to summarize this action, which is the action which you have this motion in, which is T1964-17. When I filed the motion here, or the statement of claim here, when I filed the statement of claim here, it was ID number 1 in the file. ID number 2 was my statement of my affidavit of service.
Right.
ID number 3 was what? Was a motion to disqualify BLG. This motion never been heard. Then we came in, and the motion was just very straightforward, asking for a schedule because I need to bring this motion, which is more than the allowed 2 hours or 1 hour in the standard chamber. And the motion in the record speaks on its behalf. I'm not making up this, okay? And everything I will say, I am not making it up, are not assumptions, are actually documents in either the court file or documents available for public for verification. Secondly, we came here on the same exact room on February 8th. The preceding justice, she decided to adjourn the case to case management, and my motion 3 will be decided by the case management. Then we came to March, and
Sorry, which motion of yours?
this was ID3.
ID3, that's right.
ID3.
Okay. right.
Then we came to March, and I found out motions have been filed and scheduled after my motion, and the actual Chief Justice Crampton of this court orders the action to be before case management, and Justice McVeigh did not want to adjourn it to case management, and I filed at the time a full motion record, 40, which is document 40. I'm not sure what ID at that point because there's so much IDs over there. So, and she said, yeah, this motion will be heard by the case management, but I wanna hear the other motions. My understanding of a case management is a judge cannot get himself away from being urgent, away from being life-threatened, away from whatever definition in the legal word describe an urgency to a hearing. So for the judge to decide that motion Doc 40 and ID3 will be before the case management, nothing else, and for the judge to decide, the Chamber judge to decide to proceed away from the Chief Justice orders for case management, this is for me not the standard practice inside the court, because basically the action is seized before the case management judge, and no other judges shall interfere without urgency or life threat. So, moreover, ID3 and Doc 40, I met all the requirements. I filed on time. I was so precise on the time and the dates. To date, I did not get any reply motion or responding motion from any party so far. And my also understanding of the rules of court, that the rules of court will grant a hearing for a motion which meet all the requirements, and the motion without a responding motion record within the time limit will be most likely granted because there is no written subscription. So this is one of the observation, how we came in this. The second point I want to put before the court is, on March 8, 2018, the court voice recording evidence, and if the court does not believe me, I would request to replay the audio recording of evidence that Justice McVeigh ordered, in particular, Mr. Nuttall, which is sitting here, and Mr. Tusto, which is sitting in the back, to be removed from making further submission. And I have a transcript version of it in my submission. So the judge later on in her written decision, the judge wrote a sentence saying that BLG volunteered. The reality, my lord, or not the reality, what the voice recording demonstrate is the judge from the bench order or direct that this counsel will need to change and adjourn the meeting or adjourn the hearing for 10 minutes to change counsels, which is a self-evident from the court recording. And if anyone from the opposing party or the opposing counsel wants to challenge this, I would urge the court to bring the recording and we can play it.
And so, why did she order that?
Because BLG is in a conflict.
Does she say this in the recording?
She said along this line, she said like, you are not representing BLG here and you cannot do that. So I attached 5 pages. And to be honest with you,
be precise, what did Justice McVeigh say in the recording?
She asked the counsels to go back and select a different counsel to do the representation, and she adjourned for 10 minutes.
But there could be all kinds of reasons for that. So I need you to give me her reasons, precisely what she said, why that was necessary.
I can, my lord.
I read her judgment. Is that what you're going to?
Not the judgment, my lord. I am talking about the actual court transcript.
Transcript, okay.
Yeah. So
You have a copy of that, do you?
it's actually tab 2 of my motion.
Okay.
So it speaks to itself. So, and even when they came back, Mr. Gerald said the defendant chat amongst themselves, and we thought perhaps the best way to proceed, obviously, ruling in your hand for today, and they actually changed. So
I'm just trying to find where it is. I don't have any tabs in your materials.
my lord, this will be this.
Do you have a page number for me, maybe?
Sir, for ease of reference, we've also attached the transcript excerpt that Mr. Badawi included in his materials
All right.
in our March 25th responding motion record, just for ease of reference, and that's tab S for Frank of the March 25th motion record of the IntelliView defendant.
All right.
And this is, my lord, one of the coroner evidence, or one of the key evidence.
Can you read it to me, what you have, or? What the transcript says?
So, the transcript said, I was prepared to reserve because there is a lot of material and lot of different motions, but I would very suitable, but this is certainly one option that in the next minute we can all think about. Mr. Natel responds, but we say just, they say this pleading, it's obviously deficient, and of course I believe the justice said, I read all the material, but I need to hear his argument on before. So Mr. Natel would reply, yes, we would ask that we hope that you could give a judgment today. Justice said, certainly one option. Mr. Natel said, because BLG is not instructed anyone today. Justice said, I know, I put you all in a very awkward position, and I apologize for that, but Mr. Natel respond, I wonder if you can just take a step back from the edge and refer to what Justice Hennigan thought we would occur with would be simply deal with our motion today, the motion to strike, then if necessary later it is with the proper material being filed. Just said the only one that I'm concerned is BLG being removed. The other things have to be dealt with today as far as the affidavit, and he had a list of other things on the new when he files the mootness cross-examination case management. Justice said, yes, there is a number of options. If you can talk about them, I will hear very shortly. Hear what I'm coming with, a name, and then hear your response. 10-minute adjournment. Thank you very much. Thank you. And Justice, the court will adjourn for 10 minutes. And then when we came back, Mr. Garland said the defendant chatted amongst themselves, and we thought perhaps the best way to proceed. And after that, Mr. Natel was actually, and Mr. Tosto did not make any submission, including submission on cost. So if I present...
But not upon the order of Justice McVeigh.
Sorry?
Not upon Justice McVeigh's order.
Justice McVeigh decision...
In other words, they said, to avoid the problem, we'll have someone else speak for us. So that problem was never dealt with.
This problem was never dealt with, my lord, and my point is, this record...
No, but I thought you told me that Justice McVeigh had found that they had to be removed.
Justice McVeigh suggested that, or ordered or directed that they have to be removed, and adjourned the hearing for them to be removed. They never volunteered. There is no submission on the record.
It sounds to me as though she adjourned the hearing to find out whether there could be a solution without having to deal with the problem on that day.
But she removed them from the submission, my lord. They were the only one making submission from the beginning.
No, they volunteered. They placed another lawyer in their place so that the issue didn't need to be dealt?
Because the judge told them to do so.
Well, nothing you've read me has told me that.
It is not to-
I'll go over it again, but I didn't catch Justice McVeigh saying, ordering them to remove themselves.
It was, she said they cannot represent because nobody gave instructions that they represent.
I'm going to read it carefully.
So, as I'm saying, if my interpretation is not the best interpretation, all what anybody will see is two respected counselor will stand and will speak for 45 minutes. After 45 minutes within the hearing, the judge will adjourn to change the counsel to another counsel, and she will not allow them to give even submission on cost. This is what I would say. I just summarize it.
All right, okay.
Now,
I understand your position.
later on, 3 months later, the written decision came with a completely different sentence saying that BLG volunteered. And here, I have to just make a pause and consider the following. Did BLG volunteered or not volunteering is not the situation. The point is BLG found out an issue, or the court found out an issue, that BLG are not competent, or there is an issue for them to make submissions. There is a conflict there, or there is an issue. I don't want to name it because I don't like the court. All what I can say is BLG was not permitted to provide submissions.
Okay, I understand your point.
The second evidence I want to put before the court, there is an order from Alberta Queen Bench by Judge Myler on October 1st, 2015, and this order will order BLG to submit to the court registry or the court register significant assets I own, which basically share certificates which I and my wife and my other company CTEC owns, and the original of these certificates were in the office of BLG, and BLG filed an affidavit in 2015 to confirm that BLG convey the original assets or the certificate of the assets to the court. This order and the response to the order, evidence in front of anybody that BLG has my original assets. If you want to consider how many shares, and I have the affidavit of, it's inside my material, and also this affidavit have been submitted by BLG response as part of their material. So this is classified that BLG has my original evidence or my assets basically. Now, how big is this assets? They are multi-million shares, like 9 million shares. The court can see how they look like. The last investment in this company was by Enbridge Pipeline through their investment arm, and they bought a single share for quarter dollar for 25 cents.
Okay.
So if I take 9 million, 10 million shares divided by 4 or by quarter cents, this will be worth like $4 million. So how somebody...
Do I have that in evidence anywhere?
This particular affidavit...
No, that calculation you've just done.
I believe it's inside one of my affidavits, and without the calculation.
That you filed with me for this motion?
I don't recall, my lord. We had significant fines, so I don't recall this particular calculation, so I'm not providing it. So
okay, so it's not evidence before.
It's not evidence. However, the evidence before the court is there is more than 10 million shares or 12 million shares with certificates, which the original was at BLG. So why BLG has my share certificates, and what kind of agreements I do have with BLG to keep my shares and my assets? It's myself, CTEC Solutions, and my former wife, or my wife, doesn't matter, because the Court of Queen Bench, the Court of Appeal actually struck her action. So Gada Nafi is another one. And continually, BLG has the shares of my former in-laws or my current in-laws and other people as well. So, within my record as well, I have a BLG document which is we provided as part of the cross-examination. So, as part of the cross-examination to Mr. Hughes, I provided this evidence, and is actually
Is this in your record before me?
yes, my lord. It's actually part of the record of cross-examination of Mr. Hughes.
Okay.
And I provided a legal opinion that was provided for us and for me, because I used to be the only shareholder, the only director and the owner of the company at the time in 2011, and the legal advice was provided on a BLG letterhead. Mr. Hughes recognized the legal advice, and Alan Nelson, he used to be a senior lawyer at BLG, and then they fired him after an acquisition at the Law Society 2 years ago or 3 years ago. So he provided, which is Exhibit I of William Hughes exam on 13th day of February 2019. It's actually a legal opinion how we can place investment inside the company and who are the debtors, and it shows the record of the company as well. So I will place this before the court and say I got legal advices through BLG as well.
Now, was this particular issue you're raising, was this dealt with in the QB action in Alberta?
None, my lord, nothing. What always happened to me is we bring these motions. The judges are not interested. They don't want to hear it.
No, but
So this issue is not being heard. What happened is,
you brought the issue before the court, did you?
yes, but at that time I didn't have this particular evidence.
Okay, so you brought this issue before the QB court.
Yes, we brought this issue before the QB court as part of the statement of claim. And what happened is Mr. Bruce Comba, representing BLG, filed an affidavit on behalf of BLG. BLG have been ordered for cross-examination by Justice Nation. And this part actually of what's forthcoming, so it's a good time to share. So Justice Nation ordered Mr. BLG, and Mr. Tosto, which is in the room right now, was submitted for cross-examination. Then the court dismissed the claims against BLG. However, BLG filed on behalf of Intelliviu, and Justice McCarthy 2 times allowed an amendment statement of claim, and he restored the two sections to disqualify BLG. So if the timeline is observed...
That was Justice McCarthy.
Sorry?
Which justice was that?
A justice in the Alberta Queen Bench.
But the name of the justice?
McCarthy.
McCarthy, that's what I just...
Yeah,
read.
McCarthy.
McCarthy ordered... What did McCarthy order?
Ordered that I amend the statement of claim twice. In both amendments, he allows the sections where I seek disqualification of BLG. So, if someone observes the timeline correctly, they will find out, yes, BLG with Justice Hughes have been dismissed the claims, and then another judge in a different day amends the statement of claim, and then the same judge reaffirmed the same amendment because BLG went back and they want to change something as well in the amendment. So the statement of claim have been amended twice. The version 1 amendment and version 2 amendment was basically the same. So in January 2017, I believe, there was an amendment statement of claim where it asked explicitly for disqualifying BLG.
All right.
So a prior order, as my understanding of the law as well, a prior order on a statement of claim, and when we change the amendment statement of claim, it's another statement of claim. So BLG should do something. At Alberta Queen Bench, BLG brought in, which is in my affidavit, more than 17 applications to strike my statement of claim, my statement of defense, and my counter statement of claim. And they did not get all what they want. And they keep coming and coming and coming to strike my statement of defense and amendment statement of claims. They could not do it. Now, what's the status of this Alberta Queen Bench action? Mr. Tosto sent me a requisition for trial, and there is a requisition for trial in December, have been filed in December, and we are waiting for the time for trial. So, coming back to my first question is, what is the real intention behind this motion? And who is the beneficial party of this motion? When we questioned Mr. Hughes said in his response more than 11 times that he doesn't have a personal knowledge of this affidavit, and this affidavit is produced by Mr. Tosto, and he doesn't have access to the exhibits of this affidavit. All these exhibits have been provided to him by his counsel, and the affidavit has lots of opinions and lots of interpretations and ideas or a statement of Mr. Tosto. If we go to the same exhibit, which is the opposing counsel was mentioning it, just to show the court few things here, and then I will come back, and I hope I'm making sense to the court, and the flow is clear. I hope. I have an accent, and if I go to Exhibit X, which is opposing counsel was using.
This is in
Mr. Page 271. It's volume 2 of BLG motion.
Right.
And it's the order of the Honorable Madam Gleason, which can get from any public source.
Yes.
However, on the top of this order, there is a sentence which said, from on January 20, 2015, 12/28, and it shows a number. So my question here is, if this exhibit, you can get it from any court, you can get it from Canley or law case or whatever law source information available publicly, how come Mr. Tosto will have the exact facts date where the court sent me this court order? This particular document, my lord, does not exist in the public. The content exists. I agree with the court. I'm not saying that this is hard to reach, but however, the order in this way with the confirmation does not exist and cannot be received in the public. If I go to the second affidavit.
So I'm just trying to understand your point here. You're saying that he knew the exact date when it was sent to you?
Yeah, these facts here confirm that this exact copy was faxed through a machine on January 20, 2015 at 14/28.
Right.
This date and address will be available only on document which is privileged and confidential to the lawyers, because this document in particular with these particular lines on the top of all the facts are not available. So we know from the law, which I will come and very summarize it, that lawyers and counsels shall not use privileged and confidential information on behalf of others. If I go to, maybe it will be more clear if we go to Exhibit AA.
Double A?
Alpha,
Okay.
which is on page 284. This exhibit represents a cover page. And this cover page, it's a letter from the federal court sent by Habab El Khalifa. It's sent from Ottawa. It has the fax receiving of 26 pages from the federal court on June 23, 2017.
Yeah.
I cannot see BLG listed here. I see Mr. Bruce Comba, I see Wael Badawi, which is myself. And this cover letter, in the same form factor, which includes the fax confirmation record on it on the top, does not exist in the public record. So when I asked Mr. Hughes, how did you access, do you have a personal access, or did you receive this information from, he said, I don't have access to these exhibits. These exhibits are made by my counsel, which is BLG. So I agree with the court. The rest of the order and the rest of the decision could be, by the way, it could not be obtained in the same form factor, because if I apply here for a copy, I will have with the filing stamp, and if I go to Kenley, it will not be the same format. So my point I want to drive at that many of the exhibits of Mr. Hughes are needed to be answered. How BLG accessed these exhibits? If BLG has this because they had my file previously, or they have another witness who they don't want to name, and they draft an affidavit for Mr. Hughes, and Mr. Hughes will come as a front individual who will basically affirm the affidavit. I believe, my lord, the cases which is I put before the court, it actually does not allow such a practice. If the court will go to Exhibit BB, which is on page 310, so after 26 pages of this exhibit, we go to Exhibit BB on 310. The same observation, and I believe observation is the right word. There is a court administration service sending a fax to 2 phone numbers. BLG is not there, Mr. Hughes is not there. It's dated January 20, 2017, and I still say that the court itself will not have this cover letter with the same heading or the fax stamp. And that's why I needed to have an oral hearing, because I needed, it's very difficult for me to write this information. It's very easier for the court to see. That's right. So there are at least half of exhibits from Mr. Hughes' affidavit which makes them inadmissible to the court, because he doesn't have first-hand knowledge. And this all Mr. Hughes' affidavit is actually questionable, because I presented a case which was in February 2019 in the federal court, not in the Federal Court of Appeal, where the judge clearly said having somebody to hand the exhibits to a witness is not, the court cannot accept this practice. Yeah, I understand there's a difference between affidavit of documents and affidavit of motions, but the court rules was clear that the court has to, people have to have personal knowledge. I don't gain the knowledge and come to a third party and say, okay, I will draft the affidavit for you, you read it now, you have the knowledge, and guess what? You can sign, and a lawyer will administer this signature believing that this witness swear the truth, and the witness himself, after I asked him in the very first questions, are you aware of your affidavit? He said yes. I said, do you want to change anything? He said no. And when we start to talk about it and ask questions, he started to say, oh, I don't know, my lawyer did it, my counsel did it, and I listed this clearly. I would like, if the court allow me, and I appreciate the passion of the court, to proceed to page 263, which is Exhibit V as Victor of the same affidavit. So Exhibit V is actual document that was sent to Mr. Wong, and Mr. Wong is an employee, is a lawyer in Field LLB. And
So he's a lawyer where?
in Field Law,
In field.
in Field Law, yeah, which is a company close by here now. It's a very known company in Alberta, so.
Okay.
So this particular page, which has my hand written on the top, attention Mr. Wong and his fax number, will not exist outside myself. It doesn't exist in the court. The court will have the statement of claim and the stamp, but the court will not have this particular page with my annotation on it.
Okay, it's just the annotation we're talking.
So this annotation means that the source of these documents are not the public record, and the source of these documents will be something confidential and I deserve to know if they use data they have within my file or somebody else's data. If we go to the next 2 pages down, my lord.
Just slow up a little bit now, so I can get down what you're telling me.
Sure, my lord.
Okay, go ahead.
If we go to Exhibit W, which is 2 pages down, which is W stands for my first initial, so I'm happy. It's also the same thing. It's actually a fax sent to Wael Badawi, to Ray Wong, and to Mr. Bruce Comba. And the fax came from the court here. And it has a fax annotation stamp of receiving the number of pages. And no, BLG will not have, is not a target of the cover page of the correspondence. And I asked the question, how Mr. Tosto access these faxes? Mr. Tosto can access the information from the public record. Mr. Tosto can come to the court and ask for a true copy of the original. Mr. Tosto can go to Ken Lee or Case Law or wherever. This is available for the public. But Mr. Tosto shall not have access to a document which is transmitted by the court on November 27, 2014, November 27, 2014, outside the parties who are on the cover page. So if we extrapolate or we look into more of these cover pages, there's only 2 conclusions. One is this might be my confidential information within Mr. Tosto's hands, or how Mr. Tosto receives them, and what kind of witness giving him to this information for him. And if this is not a lawful access for documents, this evidence shall not be before the court. So Mr. Hughes was very kind enough and the candidate, and he said,
Did you say it should not be before the court?
if this is not achieved and if this is not accessed
yeah.
in a lawful way,
Yeah.
if this was accessed in controversy to the code of conduct of lawyers, if this was accessed by illegal access to my record, if this was accessed by breaking privilege and condor duties, the court need to consider this as factors. That's right. This is what I'm not savvy to give the exact court cases to support what I'm saying, but I understand this is a common case law, and the CN Rail case, which I'll come to it later, in the Supreme Court of Canada, describes this kind of information.
Okay.
So if BLG denies that they have my assets or they have access to my agreements around these shareholders' certificates, and denies they have access to my private information, there is another lawyer here, which is Laura Gobel, and Mr. Frank Tosto. They have different submission. I did not make up this. This was made by them. I did not.
What are you referring to here?
What I'm referring to here, my lord, is without knowing how they can get access to this information.
Oh, it's the same point, okay. No, it was your word here. When you said here, you're just referring back to what you're doing. I understand now.
So on the balance of probability, which is there is enough evidence submitted by BLG itself to demonstrate this BLG affidavit with my assets, BLG documents, BLG writing affidavit and getting a third party to sign on it without having personal knowledge, it has to be considered by the court.
All right.
The second point I wanna move forward to it. In questioning Mr. Hughes, there is IntelliView is my company, which is I start from my lab at the University of Calgary, and I used to be a professor at the University of Calgary for 8-10 years.
Okay.
And this is my startup company from my lab. And before the court, there is enough evidence of that. So as a small company, starting company, usually the company will have contracts and will have, they cannot pay us on time and stuff like that. So in Mr. Hughes' cross-examination, I presented Exhibit A for identification is actually a demand of payment from IntelliView for renting my trailers. This demand is outstanding since 2015-2014. When I had this demand, and even when I realized that now BLG is in the midst, so I sent these letters back. Mr. Hughes acknowledged in his cross-examination he received this letter. The immediate question was, how did he deal with this outstanding loan?
Sorry, he acknowledged he received the letter, but the question
And
is...
the second question will be is how he dealt with this outstanding loan. Because it's an outstanding loan. He said he doesn't remember. So he refused to answer what happens when I have outstanding loan, and opposing counsel who gives the presentation, when we had the same exact document before the court in Queen Bench, she said that I created the document to compromise the bankruptcy before Judge Neufeld. And I attach also in my reply a correspondence coming back from Mr. Tosto with BLG logo on it in January 2017, trying to say you don't have an agreement to pay this outstanding loan. So there is a dispute on a loan. There is also a dispute on my employment conditions, and if you don't want me to be attached with my company, and how can you remove me, and there is a law and notice, and this all are part of the statement of counterclaim in the Alberta Queen Bench Court. When we had this particular counterclaim, I tried to make it a summary judgment. Judge DeWitt, who is a former lawyer at BLG, according to the Minister of Justice Bayou, Justice DeWitt told me the amount you are looking for of $4 million is much higher than the summary judgment. So you should go for trial. And he dismissed my summary judgment. So what I'm trying to illustrate here before the court is, what is the reason for having this particular application in an action which is discontinued because dismissing with no amendment the statement of claim, and having only pending hearings in the appeal court? My conclusion, my lord, is the only reason is BLG itself doesn't want a panel of 3 judges in the Federal Court of Appeal to hear my appeal, because it will create an issue for them, because this is BLG, the largest firm in the country. If we come and say BLG claims in the bankruptcy that I owe IntelliView $8,000 outstanding cost. I added the oral decision of Judge Neufeld in the evidence before the court. Judge Neufeld stayed the application. And in his oral decisions, he was concerned that they don't have any other ways to enforce payment. And he said, because it will create more friction for me, he stayed the application. It doesn't make sense from cost-benefit perspective that BLG will have at least 4 lawyers engaged with this particular motion. And you, my lord, understand how much communication these lawyers made and how thick is the file. Like I brought in what I could bring in, but this is a significant file for this particular motion. For what? And Mr. Hughes, at the end of his affidavit, he said that we cost him money. I am a self-represented litigant. I never seen a self-represented litigant will be facing 4 senior lawyers trying to attack him in this way, to write letters to all level of judgments of administration of justice since August 2018, to write to the Chief Justice, on both courts, to want to make a joint hearing between the courts, all these kind of abnormal proceedings. And Mr. Tosto, who doesn't want to give submissions today, is actually the one who signed on the written submissions of the original motion. Mr. Tosto, who doesn't want to give submission before the court, his signatures here on the cover page of the letter of December 4. So Mr. Tosto is giving information to Mr. Hughes and advising Mr. Hughes, and Mr. Hughes has no personal information whatsoever, has no access to these exhibits, as according to Mr. Hughes' submission inside the cross-examination. When we do cross-examine people, my lord, the golden rule is we don't ask questions we don't know the answer for. We ask questions to confirm that the other party is not telling the truth and the full truth. So if Mr. Tosto signing the written submission for the court in the original document, and Mr. Hughes acknowledges this his own signature in presence of Mr. Nattel and Mr. Gorowski. If Mr. Tosto signing the correspondence to the court, and it's basically a lawyer coming to the judge and the court and saying, okay, here is the facts, I would like you, court, to acknowledge these facts and take an action with it, and because I'm a lawyer, I cannot be cross-examined. The truth, my lord, is Mr. Tosto and BLG, Mr. Tosto on behalf of BLG, have been submitted to cross-examination, and they became a witness in the matters, and the evidence for that is within Mr. Hughes' cross-examination Exhibit C, which is the order of Judge Nation, and Exhibit E for Eagle, which basically the transcript cross-examination of Frank Tosto on his affidavit of August 17, 2016, the cross-examination of September 8, 2016. And if the court will just read through the very first pages, Mr. Tosto acknowledged that I am the owner of IntelliView and I am the owner of the trademarks, and the trademarks are listed under my name. When a judge will make an order for a lawyer to submit to court, the lawyer should not go after me. If Mr. Tosto has feeling his ego is really bad because he got ordered to cross-examine, I did not make the order. A competent judge, which was in a panel of my appeal, which got granted, Judges Nation, she is aware of the details because this was part of my family matter, and she made this order. I was not there. And the one who did the motion was Mr. Komba, not me. So why do I have to face this motion of fictitious? So BLG was also represented by independent counsel, and based on the based on the previous submissions, I would like the court to dismiss, stay, or strike the application for vexatious litigant, because I would like to have my hearings in the Court of Appeal, because in the principles of common law, there are two ways for accepting the court decisions: either accept it or appeal it. And anyone has the right to ask for an upper court review of the decision. Judge Cote in the Art of Appellate book, he explains this right. Judge Zinn, Z-I-N-N, of this, Justice Zinn of this court, related to me this right. So I have the right that if a judgment have been issued against what I believe is right, to be heard. So all what I'm trying to say now is BLG is the actual beneficiary of this particular hearing. When I also want to talk about Mr. Hughes' hearing, BLG contacted one of my not-for-profit, one of the organization I'm dealing with as a not-for-profit organization, because they needed some material to it. And there was an email came from...
Who did they contact?
They contacted a not-for-profit corporation called Stand For Yourself. We work with self-represented litigants, and we were endorsed by the previous Chief Justice of Canada. And we basically don't represent people, we basically connect individuals with lawyers who are allowing unbundled service, so we make them easy for them. I don't come and I don't claim, I'm not a lawyer in Canada, okay?
No, I know about the organization.
Okay.
I just needed to know who they contacted.
Yeah, so
they needed information about what?
They needed some videos, and the individual there is their IT department, and it's part of my evidence. And they need to investigate my information about me and my videos on this website. So this BLG investigation, I'm not familiar with a law firm will investigate individuals and try to make, this is just a very different practice than what I do. So now,
perhaps they were looking for some evidence they could use in this motion.
It is the mandate of a law firm to investigate, or is a Crown mandate? Is the mandate for a lawyer?
The Crown? We're not dealing with criminals.
I understand, we're not dealing with them. So my question is it the standard mandate for a lawyer is to collect evidence?
Well, you do whatever your client requires you to do.
I don't know, just I leave it open to the court. So I want to comment on the, or reply for the decisions of, for the submission of opposing counsel.
So what you've just given me is your response or your own motion?
What I give you, my lord, is my umbrella response for why the court shall dismiss, strike, or stay this application.
Okay.
Now I want to go into specific response.
Okay.
You've
already used up an hour of your time. Okay. So I told you I would remind you.
Yeah, I know. So in the very beginning of the submission from opposing counsel, they talk a lot about issues of service, and I did not raise any issues of service. So I'm not sure.
You didn't raise them where?
I did not raise it. I did not raise them today. I believe
they're in your materials.
They are in my material at the time of it, not right now.
Are you withdrawing that then?
There was no issues of service. The case management judge dealt with it, and as a matter of fact...
So you're not claiming there was no service anymore.
I did not claim there is no service anymore, and
Well, I read it in the materials that you were claiming that.
it was in November, and the court actually create for me at the
Okay,
court
all right.
cost.
That's all I need to know is that
A full copy.
service is off the table.
So I have a full copy from the court register, not
No, I
from
understand
them.
that.
So I don't know why they brought the issue of service. I believe we cross-examine on evidence, which means
All right,
self-evidence.
so all I need to know from you is service is not an issue, is that correct?
The service is not an issue, has been dealt with by the case management.
Thank you.
Now, they want to come to Judge McFay order, and Judge McFay order have been under appeal, and there is a hearing for it early May, according to what we know.
Yeah.
So, I still want to move that the only way for them to avoid this appeal to be heard is having this motion. Nobody else is beneficiary from not having this appeal. And I'm surprised to spend all of this money,
How does this avoid the appeal?
because in their opinion, if they will get me, there is one term in the order to say I cannot present without a lawyer, and I cannot afford a lawyer because these people having all of my money. So in this way, they are trying to put this term in. So when we showed up in May, I need to bring a lawyer in, and I cannot afford to do this as right now. And the rules of court and the charters of rights and
Have you provided me with any financial information that I can rely upon? Because I said you can't just give evidence. No, I said have you?
No, I don't have any financial information.
All right, then that's not evidence before me.
I understand. However, the new term just came in today. The new term of me having a lawyer, it just have been in the new draft of the order. I was not aware of this
All
term.
right, okay.
So,
Okay, you're saying that it's not fair to put that in front of you now, all right.
okay, so, one of the questions we have on Magort, which is the second affidavit, which is an employee of BLG, she provided before the court lots of information from a proceedings in a different court. And I understand from the federal court that you cannot bring proceedings in the court next door and get the court here to make decisions, because the court has different rules and different rulings. So we asked a legitimate question: why are you providing these particular sections? I did not get an answer for my questioning, and this questioning happened in writing using Form 99.
Yeah.
So we did not get any answer for this question. So why a clerk in a firm will put will compile subset of the actual proceeding in the other court? If BLG interests to retrial the Alberta Queen Bench orders here, I don't think the rules in the court and the common law will allow to be a retrial. If BLG wants to retrial Judge McFay here, which is the order which is under appeal, I don't believe that there are provision in this court or in a common law that we will take files from this court and retry it here. So we still ask question: why Marguerite? Why this particular BLG?
I don't know. I don't know what you're getting at here, but let's say, I mean, obviously, what happened in previous jurisdictions in relation to, you know, the vexation issue, previous jurisdictions, it's very relevant to what's happening here because it's something I'm obliged to take notice of.
In terms of foreign orders, there is a...
How foreign are we talking about here? You mean Alberta?
I understand, my lord, we are in Alberta.
No. When you say foreign orders, are you referring to Alberta as I mean...
What I'm referring to is court orders and court proceedings within court jurisdictions are not transferable. The court can read and rely on orders made elsewhere, and there is ways to register these orders in this court. Just bringing a full file from a court, or a selected material of a full file from the other court, and having it before the court here, and consume that much resources and so much printing for it, it underlines the intention. So if their intention is to have a retrial here, I don't think the court will allow a retrial. I demonstrate also that some of this material within even the federal court, they are not obtained from the public registry, they are obtained from some other material, from some other sources, which might be confidential resources, or it might be privileged resources. She mentioned a question about Justice Hull. Justice Hull, in particular, have been recused by the Chief Justice Whitman because Justice Hull was found erred the law in the action according to the Court of Appeal decision, which is Nafi versus Badawi, 360/2015. So Justice Hull was actually recused twice by the Chief Justice. And the Alberta Court of Appeal found him erred the law and allowed my appeal in my family matter. So why she accuses me is actually the fellow judge, the judges panel, 3 judges of rel descended, but 2 justices found out that this judge error. And we understand that if a case management judge erred the law, he will be removed from the case. So she started to talk to me about Justice Hull, and I write defamation. I didn't write defamation, it just actually was a court proceedings recused him. So why I am accused here of Alberta Court of Appeal decision that resulted in a judge removal. So we covered Judge McCarthy, because Judge McCarthy actually, in my understanding, he allows a new amendment of statement of claim, which is actually asking for disqualifying BLG. She mentioned lots of discussions about the IGRA actions, and according to the cross-examination of Mr. Hughes has in his own affidavit evidence that I have access to this trademark and establishment around 2009, which is way before I know Mr. Igros. And when I asked this question to Mr. Hughes, opposing counsel said, we are not retrying Mr. Igros' case. So you talk about too much about Mr. Igros' action, and at the same time the affidavit which is drafted by Mr. Tosto and getting Mr. Hughes to sign it, have an exhibit there where Mr. Hughes read that I have the books at that time, and the 3rd edition of the book in 2009 means that this book was around for 3 editions. So Judge Manson did not concur with my position, and this is right now in front of the...
Sorry, Justice Manson did not what?
Did not agree. Or concur with my decision, with my position, and Justice Manson is under appeal right now, and the hearing will be in May according to the Federal Court of Appeal. So I follow the court proceedings, and I follow what the court allows me. And I was here with a case management judge, and I asked for a case management judge for my action in the Alberta Queen Bench, which IntelliView started, or BLG started against me. And BLG said, no, we don't need case management because they have a different strategy. My actions in the Alberta Queen Bench have case management. My actions here have case management. And I use case management in the same proceeding. We ask information and the case management will make decisions. So I'm not sure what kind of abuse I have. The one who did not follow case management proceedings is the individuals who provide applications within this particular action to be heard outside case management, and Judge McVeigh heard it outside directions of case management. So they want to predict what I have here. I didn't do anything. I didn't have actions in this court. Now, she alluded to a decision by Judge Stratus, and Judge Stratus is a very respected judge in the Federal Court of Appeal, and she handed decisions to your lordship.
Yes.
The same judge wrote a direction within my appeal directing the council to stop writing letters to the Alberta Court of Appeal. It's the same judge, and I have this in my material. So in my appeal 245, 8A245,
To stop writing letters to the Alberta Court of Appeal?
to the Federal Court of Appeal.
I thought you said Alberta.
No, the Federal Court of Appeal.
No, that's why I thought it was strange.
Because the councils will write letters to the federal court. Now, for me, as a self-represented litigant, when I see these letters, I respond to it. So I shouldn't be blamed that I'm responding for a council what defined under Judge Stratus. It's bizarre to see these letters and waste of the court time. And you, my lord, understand if I don't respond, the court may make decisions on these letters, and I have to bear the consequences. So my defense is allowed because the Federal Court of Appeal allows the defense of abuse the process as a legitimate defense according to my written submission. And
Sorry, I'm not following.
I'm talking now about the law. So
The Federal Court of Appeal.
the Federal Court of Appeal allowed.
In which case? What are we talking about here? Is this a case involving you?
This case, my lord,
No, I just need to know where you're taking me here. You said the Federal Court of Appeal allowed abuse of process. When? How? What?
abuse a defense.
It's a defense.
Abuse the defense.
Okay, that's all you're saying, then I'm fine, all right, sure.
Abuse the defense.
I think we all know abuse of process is a defense, okay.
Okay.
Yeah.
And I quoted the case in my material.
Okay, yeah, no.
So what I'm submitting here is the moving party behind this application is not IntelliView, and BLG may not even have instructions from IntelliView.
No, I understand that.
The moving party from this application is IntelliView, is BLG itself.
Yeah.
The one who put affidavit before the court is BLG. The law is clear in few aspects. Number one is the federal court rules say affidavit has to be based on a personal knowledge.
Rule 82, I
Yeah, and the other one is the Code of Conduct 5.2 of the Alberta Law Society said, if a lawyer is a witness in a proceeding, the lawyer shall not interfere with the appeal of this proceeding, which is section 5.2.2 of the Code of Conduct. So for Mr. Tosto, he's a witness in this action by order of Judge's Nation, and the inclusion of his statements all over from my side and from BLG's side and in all this case, in all of this affidavit. And Mr. Tosto testified on behalf of BLG. So I submit basically that between these two rules, BLG shall not interfere. And if I will flip to my motion of why my motion 50 under Rule 51, I will use all of this as umbrella
Yes,
background.
yes, okay.
And
Is that where you're going now?
Yeah, this is what we are going now. So summarize what we did.
Yeah.
I would apply for the court to strike or to stay this application,
Okay,
at least till the Federal Court of Appeal hearing happen, or at least if I come back again, because I'm not here, I did not file any other motions or any other applications in this court. I'm actually defendant. Now I want to move to motion 51, under section 51. And can I grab another water, because this is empty?
Yes, by all means, let's see if we can find you one. Is it over there? Good.
Thank you, ma'am. So, my motion under section 51 is I would like the court to overturn and review the decision of the proprietary, in particular the cost, for primarily two reasons. Reason number one, in CN, in Kushner case from the Supreme Court, they said that disqualifying a law firm, and this is a CN case, which is I have it in my case. They said there are two things. Number one is you can disqualify for a conflict of interest, and when we talk about disqualification, this is the only remedy when a law firm has conflict or perceived conflict or I claim of conflict. The same decision also will talk about priority of applications. So if someone will come with a priority application and say a motion ID 3 and the motion Doc 40, they need to be decided first. From common law, they need to be decided first. And to be honest with the court, if any of these courts, Alberta Queen Bench or the federal court, heard my disqualification application first, I wouldn't be standing here. So disqualification is it goes to the integrity of justice and integrity of common law. I also include that the proper test is correctness, and I also include what exactly the court should look at. And one of the paragraphs was included in my motion was what will happen in a similar case. So it's clear Supreme Court disqualified the law firm. However, the law firm, as of background for this particular action, the law firm was actually disqualifying itself way before the Supreme Court made the decision. So I'm standing here and say, I have now a motion made by a law firm not representing anybody, because I don't think IntelliView at its own size will afford this 4 lawyers at their hourly rate and will afford making all of these copies.
Well, it's a little speculative unless you have some evidence. I mean,
My lord, this company is like 6 people.
do you have some evidence?
I have, because I asked Mr. Hughes to submit evidence of the financial statements of the company to be able to demonstrate he can afford what he say, and he rejected. This was one of my questions. So if I wanna like from cost benefit perspective, it doesn't make sense. And by the way, Judge Neufeld, this was my only submission which he held, that it doesn't make sense you bring 7 lawyers in 3 days hearing in the appeal court, in Alberta Court of Queen Bench, because you're trying to claim $8,000. It doesn't make sense. So this presence of Judge Neufeld is sufficient to establish a precedent that BLG representation or BLG itself was aggressively trying to get me to have the upper hand. And I quote in my submission the decision of Judge Neufeld. Justice Neufeld promised a written decision, and suddenly he called us up to go there at 8 o'clock in the morning to hear the decision from the bench, because this is what he wants us to hear. So there is establishment in November 3rd 2018, by Judge Neufeld in 3 pages decision, that BLG is looking to pick up the upper hand in the litigation. That's it. Upper hand in litigation is a malafide or bad intention to bring motions in the court. So based on that, I plead to justice to have my disqualification application shall be heard first. Now, it will be granted or not is a different story. However, there is no response and there is no reply to my motions. So I wonder why the case management judge did not want to hear them. Mr. Natal, in the phone call,
Let me just jump back. If you get the designation here that the defendants are seeking, that won't stop your hearing, your motions being heard.
it will give them the upper hand against me, my lord. And why do you want to designate me if I did not?
All it will mean is that, some judge will just have to check just to make sure that you're acting reasonably.
So why they are insisted to doing what they want to do? So what they want to do is very straightforward. They want to put me through bankruptcy, so they get access to my intellectual property, which they cannot get access to it through the court, through the receiver that they brought in, and then they want to come here to the appeal court, to the federal court, to change the the registry of the CIPO. This is the plan. Instead of Mr. Hughes,
Whoa. I realize that you have a theory.
it's not a theory. It's a plan disclosed to Mr. Hughes.
And which piece of evidence would you like?
There is an affidavit within my disqualification application which has this information on it. Because Mr. Hughes came to me one time and he said,
No, is it in the record before?
not this record, but in this court record, in the affidavit within my document 40, within my motion doc 40. And I believe it's also spelled out in the notice of motion.
So you don't have this document 14?
It's inside the court record. It's not within the motion we are talking about right now.
No,
But
were you unable to produce a copy of that for me to look at?
I can produce, my lord. There's a copy in the it's in document 40, motion doc 40.
I can look for it.
All right.
So
We'll see if we can find, we've got a problem, you'll have to help us.
no, I'm more. At the end of the day, you, my lord, are serving justice, and at the end of the day, I'm an audience and follower to the judges you brought in.
Okay, tell me about document 40 and what it'll tell me.
So motion doc 40 is a motion to disqualify
Yeah.
BLG and the naming specific law firms for conflict of interest. And the part of the evidence there is one time Mr. Hughes came to me and he said there is a lawyer who told him instead of having a formal license of technology, he has an alternative way of getting access to technology through the court.
Right.
So what we have been seeing right now from BLG is dragging down applications, and this is what happened in Queen Bench. They went in through so many applications for over 3 years now, from 2016 till today, because they don't want to have resolution, they don't want to allow cross-examination, they don't want to provide evidence. It's basically dragging down to mischief and burden me and mischief my resources. A good example of the mischief, my lord, is this particular motion. This motion started with a letter to Chief Justice Crampton and the Chief Justice Alberta Queen Bench asking for a joint hearing of one motion back in August. And the both judges said it's never been before, because there's different techniques and different jurisdiction and different approaches and different rules which combine both courts. And when we ask about having a copy of all of this communication, which is one of my undertaking requests, they don't want to provide. So you claim you got a letter from the Chief Justice of Canada, the Attorney General of Canada. And the ministry communication came back to me, said they are not dealing with these matters. So I asked a legitimate question: can I see the communication with the Minister of Justice? And we understand the code of conduct of lawyers that you cannot just have communication on my matters without including me, without copying me. However, they reject this undertaking. So, if the court agrees that abuse of process is a legitimate defense, I need answers from Mr. Hughes and Ms. McGirt to my questioning, because they are very relevant to evidence and the proof that BLG is conducting outside the code of conduct and outside the standard rules of court and the common law by collecting information and evidence which is privileged and confidential, and bringing some other party to witness a statement and affidavit which is not their personal knowledge as required by the law. So these are the two arguments inside my motion 51.
Okay.
Summarize, argument number 1, my disqualification motion shall be heard early on,
Right.
and they have not been heard at all. And if you have a muted or a mute action, and BLG wants to come back and bring an action, this will constitute enough interest on my end to hear my motion for disqualification first, without you, my lord, hearing their motion, and without them communicating. The second element is all questions I provided, and I can go through the questions if the court will allow me and have time for that. All my questions and undertaking need to be answered. They are very relevant to evidence that Mr. Tosto had an unusual or different way of accessing material which might be coming from my own file within his hand. Or he has to tell us how he got. Now, will the court allow us to go and ask the law firm? I've seen it in it's legitimate.
So just let me
Yes,
write
sir.
down what you're telling me.
Sure, my lord.
Yes, okay, I understand why you want to...
So as I said, this is why, my lord, at the very beginning, my submission was not in a written way. It's basically the whole motions are very related,
Yes, no, I understand that.
you know.
I understand that.
And at the end of the day, I appreciate the court willingness to listen to me, and
Well, that's what they pay me for.
and I will be replying to any feedback from.
Sure, so that's good. So you've got your response out of the way, and you've got your motion out of the way. So we're now into reply and response.
Thank you, sir. We have today, and in our materials on behalf of the IntelliView defendants, attempted to paint a picture of Mr. Badawi's conduct for the court in the October motion record. It's our submission that Mr. Badawi's motion to appeal only adds color to the canvas. Mr. Badawi is asserting that his questions and undertaking responses, which in our submission, Prathonatary Milchinsky correctly determined, were out.
Are you dealing with response first or reply? Which motion are you dealing with?
I'm dealing with...
Oh, both at the same time?
I think they're interrelated, sir.
All
And so
right,
my
okay.
submissions are primarily a response to the appeal motion.
Okay.
But it'll be my submission that the appeal motion further demonstrates the necessity of an order today.
Understood. Okay.
Mr. Badawi appears to be asserting that the questions and undertaking responses which the Prathonatary correctly determined were outside the scope of the Section 40 motion are relevant because the Section 40 motion is in and of itself an abusive process. This is what Mr. Badawi says. And if I understand correctly, I think he's saying that the Section 40 motion is an abusive process because BLG is somehow in a solicitor-client relationship with Mr. Badawi and is breaching that relationship, its obligations in respect of that alleged relationship, and that BLG is somehow attempting to gain an upper hand in litigation. Mr. Badawi's materials, or submissions and materials, are rife with misrepresentations. I'm going to try and take you through those misrepresentations. In many cases, the evidence which Mr. Badawi relies upon in support of his assertions speak for themselves and actually demonstrate the opposite of what he's saying. I'll first address the solicitor-client relationship alleged to exist. This is a relationship which the evidence does not demonstrate ever existed. It is an issue that Mr. Badawi has repeatedly raised with this court and other courts. I'm going to take you, sir, to Schedule I of the March 25th motion record filed on behalf of the IntelliView defendants. So that's the March 25th motion record, responding motion record, and it's tab I.
What will I find there?
You'll find, sir, a transcript of a motion in the Court of Queen's Bench before Justice Hughes on June 29th, 2018. This was in the context of an appeal by Mr. Badawi of a master's decision to summarily dismiss a counterclaim Mr. Badawi brought against BLG directly.
Right.
So again, he makes the same allegations of abuse and a solicitor-client process before Justice Hughes. And I think it's important to note that Justice Hughes walks through the indicia of a solicitor-client relationship and considers Mr. Badawi's arguments in the context of that indicia. I'm going to read you a short excerpt from that transcript on page 23 of the transcript.
Right.
And beginning at line 33, this is where Justice Hughes sets out the indicia of a solicitor-client relationship from Justice Hillier's decision in Gaynors and Pocklington. She says, Justice Hillier sets out some of the indicia that would be indicative of a solicitor-client relationship. A contract or retainer. There is no evidence of that here. A file opened by the lawyer. There is no evidence of that here. Meetings between the lawyer and the party. There is no evidence of that here. Correspondence between the lawyer and the party. There is no evidence of that here. A bill rendered by the lawyer to the party. There is no evidence of that here. A bill paid by the party. There is no evidence of this here. Instructions given by the party to the lawyer.
We have a problem with the phone. No, sorry, we were in instructions.
Instructions given by the party to the lawyer. There is no evidence of that. In fact, it's contrary. The lawyer acting on the instructions given. There is no evidence of any instructions given. Statements made by the lawyer that the lawyer is acting for the party. There is no evidence of that. She goes on page 24. A reasonable expectation by the party about the lawyer's role. Mr. Badawi says, look, as a major shareholder, I had that expectation. That may be, but I don't find that it is a realistic expectation. Legal advice given. There is no evidence BLG ever gave any legal advice to Mr. Badawi. Legal documents created for the party. There is no evidence of that either. Justice Hughes indicates on page 24, line 16, that there is not a scintilla of evidence that Mr. Badawi had any dealings with BLG at all. She goes on to say that she could not find that any solicitor-client relationship ever existed between BLG and Mr. Badawi, nor could she even find that there was a near-client relationship. Now, Mr. Badawi has alleged that Justice McVeigh recused BLG or dismissed BLG from acting. I would welcome the court to read the transcript. I don't intend to go through it. That's not what the transcript says. What the transcript shows is that the matter was adjourned to allow counsel time to consider how to address Mr. Badawi's complaint that BLG should be removed. Counsel voluntarily had other counsel present the argument to avoid any unnecessary delays with the motion to strike Mr. Badawi's claim, and that's clear if you read counsel submissions after the adjournment. As indicated in our submissions before Prathonotary Milczynski, and as noted in the Prathonotari's reasons to deny Mr. Badawi's motion to compel, Justice McVeigh notes at paragraph 34 of her decision that while Mr. Badawi's motion for removal is moot because she had dismissed his amended statement of claim, she also said that Mr. Badawi had not convinced her that any counsel needed to be removed. Mr. Badawi has raised a number of pieces of what he says is evidence to support this relationship. We have, for ease of reference, reproduced much of this evidence in our responding motion, and we address the evidence in our responding motion very briefly, and some of it we didn't address, so I'll speak to that as well. Mr. Badawi says that Borden Ladner Gervais was in possession of share certificates, and as a result, it was holding his confidential information. He also says that BLG also holds share certificates of other family members and other parties. I don't think he's alleging that BLG is also those parties' counsel. The Justice Miller order that's in Mr. Badawi's materials is an order that was granted in Mr. Badawi's family or divorce action, directing that share certificates be delivered into court in respect of a property distribution matter. BLG is not counsel to any party in that action. BLG was made aware of the Miller order and is the registered office of IntelliView. It holds the IntelliView minute books, which contain the share certificates. So you'll see from the evidence provided by Mr. Badawi and in the affidavit of Mr. Tosto that's also contained in the evidence, which I'll get to in a moment, BLG delivered up those share certificates to the court in accordance and in compliance with Justice Miller's order in the family action with respect to the division of property. Mr. Badawi references a memorandum in September 2011 demonstrating that there is a solicitor-client relationship, that Borden Ladner Gervais was providing him with legal advice. The plain reading or a cursory reading of that memorandum will show that that's simply not the case. That memorandum is attached as tab D to the March 25th IntelliView motion record. And what it shows, and as is explained in the motion record, is BLG was providing legal advice in respect of a Fidelitor loan, Fidelitor Inc. loan to IntelliView, and was looking at the personal property registry with respect to registrations made against IntelliView. Mr. Badawi is not referenced in this memorandum. It's not legal advice to him. In his materials, Mr. Badawi alleges that this memorandum represents evidence that BLG was providing him with legal advice with respect to intellectual property. It doesn't do that either. Mr. Badawi references the affidavit of Francesco Tosto, Mr. Tosto, which is found at tab H of the reply memorandum. Now, this affidavit was not filed in this action. It was filed in the QB action. And you'll see from paragraph 11 of the affidavit that it was made in support of an application for summary dismissal of the counterclaim Mr. Badawi had brought against BLG. There is nothing in the affidavit or the transcript excerpts that Mr. Badawi has included in his evidence, and which are reproduced at tab H of IntelliView's materials. There's nothing in here that has been refuted. This affidavit indicates that IntelliView is BLG's client. There's no dispute to that. Mr. Badawi indicates that a number of admissions are made in the affidavit and the transcript. I welcome the court to read it. It's short. No such admissions are made.
Excuse me.
Mr. Badawi talks about an amended statement of claim that he filed in the QB action, in which Justice McCarthy essentially restored the claim summarily dismissed against BLG. Justice McCarthy did no such thing. I've referred to this in my main submissions. Justice Hughes addresses this in the transcript at Exhibit I to IntelliView's materials. And Justice Hughes says the issue of the summary dismissal application against BLG was not before Justice McCarthy. He did not rule on that issue. So she's advised Mr. Badawi of this already, and here we are yet again having to respond to this allegation, which simply makes no sense on the record. Mr. Badawi has raised issue with the exhibits appended to Mr. Hughes and Ms. Mogert's affidavit. He says they are confidential information likely taken from his file. What these documents are the substance of the exhibits are public court documents, and whether these documents were taken from Canley or received from counsel on the file, the substance of the document is a public proceeding, and so there's nothing or no improper conclusion that can be drawn from this. This is a conspiracy theory.
What about the notation he raised?
Well, what he raises, and I'll go to one example. So, for example, he's raised that the first page is a fax cover page from the court addressed to himself and to legal counsel involved in the file.
Yeah.
That's not confidential information. There's no evidence of BLG having any access to Mr. Badawi's private files. That idea is ludicrous. And if counsel involved on the file, Mr. Bruce Comba, provided these records. There's nothing improper about that, sir. There's nothing confidential about those records. They're public records. So if there's a fax line or a notation that says, "Attention, Mr. Wong, counsel from Field Law," that's not confidential information. There's other misrepresentations with respect to abuse that Mr. Badawi has raised. For example, he talks about non-compliance with case management orders and the fact that an application was brought before Justice McVeigh in this proceeding outside of case management. What Mr. Badawi doesn't say is that when Justice McVeigh's decision was rendered, it was rendered at the same time as the case management direction came down. So we're skewing the facts here to make allegations that are simply unfounded. As noted by the Prothonotary in her decision to deny Mr. Badawi's motion to compel, the affidavits filed by Mr. Hughes and Ms. Mogert are limited in scope. They are largely procedural in nature, and they set out chronologies of events appending public court documents. Mr. Badawi says, this is not within Mr. Hughes' personal knowledge, and that's contrary to Rule 81. What Rule 81 says is that affidavits shall be confined to facts within the deponent's personal knowledge, except on motions. And these are motions. This is a motion pursuant to Section 40, supported by the court record. So these affidavits were used as a mechanism to get the court record before this court. Mr. Badawi makes allegations that this is not IntelliView's motion, but BLG's motion, and that there's some improper intent. I'll just take you to, or I'll read out for you certain sections of Mr. Hughes' affidavit. Mr. Hughes is the executive chairman of IntelliView and swore the affidavit. He says at paragraph 3 of the affidavit, Mr. Badawi's inappropriate use of judicial time and resources has caused IntelliView to incur significant and otherwise unnecessary legal costs and an inordinate amount of time and resources to respond to his meritless claims and applications. He says at the end, in paragraph 100, that the abusive and vexatious conduct of Mr. Badawi, as set out in the above noted actions and noted on multiple occasions by both the Court of Queen's Bench, Federal Court of Appeal, have caused significant financial burden to IntelliView, together with a diversion of resources that should have otherwise been available to focus on its business and operations. So Mr. Hughes has said why he's brought this application, but frankly, it's irrelevant. If the evidence is sufficient on its face to demonstrate vexatious conduct, the court has the discretion and the ability to grant an order pursuant to Section 40. Mr. Badawi has made the same allegations over and over and over again, and they only serve to demonstrate the necessity and appropriateness of the order sought today. He has provided no evidence to support his bald assertions. And is persistent in them. For those reasons and the reasons I've already stated, the vexatious motion should proceed today. I'll summarize the appeal motion by saying that, the submissions are in our written materials, but this is a discretionary order of the Prothonotary, which is not subject to a de novo hearing and should only be interfered with when such decisions are incorrect at law or based on a palpable and overriding error with respect to the facts. And on both standards, if you read the Prothonotary's reasons and the reasons for the rejection of the questions and the undertaking responses, the appeal motion must fail. Subject to any questions, those are my submissions.
No further questions. Thanks for your help. All we have left is your reply to the issues in the appeal motion.
Yeah,
and that alone, not the.
There is a new information, my lord, have been said here.
Sorry.
She said a new information. She said, when your lordship asked her about the source of the annotation document, she brought us Mr. Bruce Comba. So now, the fundamental question are, this is facts and affidavit and submissions of BLG, that's BLG now saying.
I'm sorry, what's this got to do with the appeal motion?
Because this is a new information. That's Mr. Bruce.
No, what's this got to do with the grounds of your appeal of the Prothonotary's motion?
What it has to do, my lord, is...
Which is about the,
If
the
Bruce
ability
Comba,
to-
it's a lawyer in Emerly Jones, and they claim that they provide this, that Bruce Comba provided them with the documentations, it means that Bruce Comba himself provided them with privilege material for his clients, which get back to the same iteration of the same principle. If we cannot get answers, how did you access this material, and this material are privileged, it means they are not admissible. And if this is not admissible to the court in form of affidavit, the motion will not have the proper evidence behind it. Is it a discretion or not discretion to the court? It illustrates that BLG itself is providing information to the court as their own evidence, and now they are also litigating on this their own evidence, and I'm standing on the other end showing documents from BLG seeing different information. The court has rejected effort to file affidavit which attach as exhibit substantive evidence from another person, largely on the basis that this would shield the evidence from cross-examination.
What are you reading from here now?
It's my submission to you, my lord, on page 20.
Page 20 of your submissions on
Yeah,
your-
section 35 is the action. This is what ME Production Inc. versus Doe 2019 FC 2014.
Okay, this is an authority you want me to read.
This is one of the authority.
Okay.
So if it's true that these exhibits have been taken from another person, which is Mr. Comba, the court rejects the efforts to file such an affidavit, and the Honorable Justice provides so much references here. Counsel talk about Mr. Hughes' opinion, and they cite the first messages to Mr. Hughes. Mr. Hughes, this is not his opinion in his affidavit. This actually is the written of Mr. Tosto. So here I have a counsel reciting another counsel, and they just use signature of Mr. Hughes. The counsel said Mr. Hughes is a chairman. We asked Mr. Hughes to provide us evidence that he's a chairman. He refused. The counsel say they got direction from IntelliView. We asked for this information. They said no. This is my questioning. So in reply, I would say that the only party which is serving and fire back for revenge against me because I raised question which makes them feel not good is BLG. And the court shall not allow lawyers to admit affidavit and litigate on the same affidavit at the same time, because this is not how the court, my understanding of the court. I adopt my submission to your lordship, and as I said, I don't have any actions, and I have no intention to do any actions in the federal court. I have 2 hearings which I hope to be able to be heard in May in the Federal Court of Appeal. I believe I'm done with the course in Canada, and if I will come again, the court usually give me a case management which is sufficient enough to give me guidance and manage my attitude and my submission to the court. So, and I believe this is I reply to them. I leave it to the hand of the court. I put all my exhibits, and we finish before time. So,
You've done very well.
yeah, thank you, my lord.
Well, thank you. Thank you for both sides. Okay. I think I've got a feel for the debate now. And so I'll go away and I'll get something done as soon as I can. I do thank you, both sides, for your efficiency here. I didn't expect we would be finished by 12:30, I have to say. Anyway, nice to see everyone. Take care.
Order report?
Yes, I am reserved.
The special session of the federal court at Calgary is now concluded. Thank you.